Number 6, common estate planning mistake is fearing probate. Probate is something that people often say, avoid it at all costs. I hope through the discussion so far about protecting assets for the surviving spouse through a will with an asset protection supplemental needs trust, you'll see that there is a benefit of probate in the right situation. If you can protect $500,000 or one half of the estate or more than half of the estate, which can be done through having a will, and it goes through the probate process, and it makes sense to do it because we want to protect assets for the surviving spouse, then probate is not just appropriate, but really it is the only thing that an estate planning and elder law attorney should be telling you is your plan. So whenever somebody says to you, probate is to be avoided at all costs, they don't understand what they're talking about. So probate makes good sense sometimes, like I just described, and probate makes no sense other times when there's no benefit of probate. Probate should be avoided if we can transfer all assets through transfer on death and pay on death to somebody that doesn't require any kind of asset protection. Probate should be avoided if your plan is a revocable living trust plan and that makes sense to you. So when you hear the term probate, which is simply the legal process to administer an estate, when there is a will, the will is filed with the court grants authority to the personal representative. They're called the executor. They grant letters testamentary. The personal representative gathers up the assets, pays necessary debts, funds the trust, or gives the assets to whomever should receive them. That's probate. And in Washington, typically it's a non-intervention probate, meaning the court is not involved except for at the very start when the court signed the order on probate. From then on, the personal representative does what they need to do without any kind of court intervention. So probate isn't to be avoided if there are benefits to the probate.